This video explains Christiane Wendehorst's 2024 discussion draft principles for AI in contracting, or PAIC. First point, PAIC is not an adopted statute or model law. It is an individual scholarly proposal. But it matters because it is one of the most theoretically detailed attempts to explain how contract law should work when software agents negotiate, conclude, perform, and manage contracts. PAIC is not specifically designed for business-to-consumer contracts or equivalent protective regimes. It also does not regulate the contract between the operator and the software provider. And it firmly treats the electronic agent as a tool rather than a legal person. At the same time, PAIC uses a broad idea of automated contracting that runs from preparation and negotiation through fulfillment and contract management. PAIC starts from a strong attribution rule. Principle 5 says the output of the electronic agent is attributed to the operator whether or not the operator still has control. In other words, the operator bears the basic risk of malfunctions and unforeseen developments. That is the core architecture before any exception is considered. PAIC then adds specific relief where control is lost. The counterparty cannot rely on attribution if the counterparty caused the loss of control, knew or should have known about it, or if its own electronic agent detected or should have detected the problem under agreed specifications. PAIC also adds a separate hardship clause. If the counterparty learns of the loss of control only later, and reliance would be clearly inappropriate, attribution may still be softened, though the operator must indemnify reliance losses. PAIC's most distinctive move is Principle 6. It says every automated contract can and should be understood as resting on a framework agreement, meaning a contract or similar legal relationship that determines whether and on what terms the parties are bound by agent output. Wendehorst presents this as the key to solving recognition and capacity problems without giving the agent legal personality. Once PAIC introduces the framework agreement, it builds a hierarchy for governing rules. Mandatory law comes first, then party-specific agreement, then accepted third-party terms such as platform rules, then statutory defaults. If no specific framework exists, Principle 9 supplies a deemed default. That default changes depending on whether the operator disclosed a specific type of agent, disclosed only general agent use, or did not disclose agent use at all. The most important reason many researchers pay attention to PAIC is Part 4. Here PAIC tries to explain how ordinary contract law should operate once electronic agents are involved. Unless the framework says otherwise, PAIC keeps ordinary contract law in place, but where a rule depends on specifically human elements, it often substitutes agreed technical specifications for those human elements. Principle 13 deals with cognitive states like awareness, knowledge, and notice. PAIC treats those states as present in the operator not only when the human operator knows, but also when the information reaches the electronic agent and the agent can duly process it. There is also a rebuttable presumption when the agent ought to be able to process the information under agreed specifications. But PAIC adds an escape clause, so this logic does not overrun rules whose purpose would make that result inappropriate. The reading note treats Principles 14 and 15 as especially delicate parts of PAIC. Principle 14 can deem intent present when the outcome is foreseeably associated with the agent's design goals. That is powerful because it moves from foreseeability toward intent. Principle 15 can also make the operator liable when the agent falls short of agreed specifications, even if the operator's own personal fault is not the only issue. PAIC justifies both moves with the idea that parties should not hide behind the algorithm. So the value of PAIC is not that it is already binding law. Its value is that it offers a full theory for automated contracting, especially on issues that MLAC and DACC leave less explicit. But the same ambition creates open questions. Does the framework agreement concept deem too much into existence? Does foreseeability really justify intent-level consequences? And does Principle 15 move contract law towards something close to strict liability for agent defects? Thank you for watching.